Hello, everyone, and welcome to Police Off the Cuff, Real Crime Stories. I'm your host, retired NYPD Sergeant Bill Cannon, a 27-year veteran of the NYPD. So we have some interesting happenings in the Bryan Kohberger case. Of course, the Idaho 4 students that I'll put on the screen, Ethan Chapin, Kaylee Gonzalez, Anna Knodel, and Madison Mogan. I don't ever want to lose sight that is who this case is about, not this guy right here, even though you would think it's all about him. Well, he's the one being tried for it. But some of the things we're hearing right now, of course, is Kohberger's defense team. And of course, that's Ann Taylor. You see the blonde-haired lady standing next to Bryan Kohberger. They're accused of tampering with the jury pool. And we'll get into why and how that happened and what it means. One of the things that we have to remember here as people that have been watching this case from the very beginning, and if we realize this occurred on November 13th, 2022. It does, I mean, it seems like a long time ago, right? And they're saying that it probably will not go to trial until 2025. So there's been a lot of feet dragging on this, I would say, under the guise of this insurmountable amount of work and evidence to go through and discovery. And that's all true, but it still doesn't have to be dragged into 2025. So some of the things, one of the reasons that we're looking at that the defense team is being accused of tampering with the jury pool is because they decided to hire a firm that specializes in jury surveys. And they called on the telephone 400 people, potential jurors from Latah County in Idaho, thus tampering the jury pool. Those 400 people could never, ever be put on this jury now because they were tainted. But there's all kinds of legal arguments going on right now. In fact, there's a live hearing going on right now in which the defense for Bryan Kohberger is arguing before Judge John Judge. And Judge John Judge is starting to be accused of being a little soft because, again, this is a death penalty case, right? And the last thing Judge John Judge wants is to give a reason, any type of reason, upon a potential conviction in this case for there to be an appeal. However, he also has to run that courtroom. And it looks like to me personally, and maybe you disagree with me, that's fine, that she's running roughshod over this judge right now. And they're doing everything, the judge and the prosecution, bending over backwards to make sure that everything is done correctly. But you also have to run the court with a firm hand, or else the defense or even the prosecution can run roughshod over the judge. And that's the last thing, the very last thing any of us want to see here, is anyone running roughshod over the judge. So folks, hold on to your hats. You're about to enter true crime from a police perspective. You're about to enter the off-the-cuff zone, the police off-the-cuff zone.
There has to be some common sense.
Yes, sir. They have the car stopped at Tampton Ranch, Michael Byler.
We still don't know who pulled the trigger.
You know, tonight I'm so privileged to have a co-host, an expert, retired NYPD sergeant, professor at Albertus Magnus College in Connecticut, a law degree, and I'm glad I have the law expert with me tonight. Welcome to the show, Professor Michael Geary. Mike, welcome.
Billy, good evening. Thank you for having me on. And hello to everybody who's tuning in. Welcome.
You know, Mike, one of the things, and you know, right now, I believe that the hearing is still may still be going on. It was live on Law and Crime, but they're talking about, and you know the deal here, right?
Right.
The defense hired a firm to basically do a survey of the Latah County community. They called 400 people, and they asked them questions to do with this case. And by asking some of these questions, and some of them, they fed them evidence. They fed them information, which perhaps they had never read before. But that is what the judge and the prosecution is objecting to. First of all, there was a non-dissemination order.
Right.
And that means it's a gag order. And the defense attorney blew that to smithereens. And I don't care, anyone wants to say, oh, she blew it up. She didn't just burn the bridge, she blew it to pieces.
Yeah, Billy, it's last month, judge renewed the gag order, and both the prosecution and the defense are not to communicate with any potential jurors in any way, shape, or form. And their first, go at the jurors to interview them is when they're picking the jury pool, going through the jury pool, assembling them, and picking the panel that's actually going to be listening to the case. And what they did wasn't like weren't standing on a street corner and asking passerbys, hey, what are your thoughts about the Kohberger case? Some of the questions that they actually used, they called people, cold calls, and they asked stuff about, they asked whether or not did you know that people claim that they live in fear until Bryan Kohberger was arrested? Have you ever heard that Bryan Kohberger actually stopped and talked to one of the victims? Did you ever hear that Bryan Kohberger had followed one of the victims on social media, planting actually ideas in people's head through these questions? Someone was so freaked out about it, they complained to the Latah County District Attorney's Office. And that's how this whole Megillah erupted. Totally improper.
Well, Mike, one of the things that I find, and look, I don't have a law degree. I was in the police department for 27 years, and I've been around the court a lot. But what I find, it's almost like it's a stacked deck, because the defense wants a change of venue.
Oh yeah.
What better way to get a change of venue than to taint the jury pool yourself?
Exactly.
That's why I'm shocked that the judge isn't like furious. Absolutely furious that the defense did this, because she just tainted 400 potential jurors, right?
Right.
And what her excuse was, and I'm going to play a little bit of the hearing from before, is that the probable cause affidavit gave the whole community, gave all the citizens information on what the prosecution had, the evidence they had. And if anything tainted the jury pool, that was it, the probable cause affidavit. Your thoughts?
Billy, even if she felt that way, that the district attorney, through releasing, those affidavits, making them public, even if she felt that way, it still doesn't justify her revenge, jury pool tainting. If she wanted to make a complaint to the local bar association, the prosecutors bar association, the county bar association, Utah State Bar Association against Bill Thompson, or she could have brought it up to the judge and asked for asked him initiate some sort of disciplinary proceeding, have a hearing on this sort of thing. That didn't happen. And it seems like she unilaterally decided all on her own that perhaps, I'm not going to wait until I'm picking the jury in the box. I'm going to do this now. I'm going to preempt everything, and I will taint the jury pool I'm a very cynical person, so I think this way. And she can claim that she did it not directly, but indirectly through this third party, this company, and that she had no way of knowing what questions would be asked. So she could get the results she wants and then wipe her hands clean and say,
That is so, Mike, that is so lame, so not believable, and
right,
so against. I mean,
right,
first of all, if the prosecution did something like this, I
right,
think everyone would be throwing up their hands and saying prosecutorial misconduct.
exactly.
Now, the defense is doing this, and I find what Ann Taylor did extremely egregious. First of all, at the very least, she violated the gag order, and she is an officer of the court.
She could be held in contempt. Sure.
Yes. But would the judge ever do that? No, because he won't do it, because then he'd open himself up for an appeal before this case even gets started.
Right.
So it's like she sort of got him by the kiliones, as we say in New York City.
Yeah. Look, she doesn't have much to work with. I mean, they have the touch DNA that they originally had. They had they also verified the accuracy of that touch DNA with the DNA test later on, much more thorough, done in Pennsylvania when he was picked up. So they know they got him on this. She doesn't have much to work with. She doesn't have a good deck, a hand of cards to work with. She knows where this is going. She's doing her best. I personally feel that she's gone way past the canon of ethics, and she's supposed to zealously advocate for a client, but zealously advocate within the bounds and guidelines of your ethical duty under the state code of ethics for defense attorneys. She's gone way beyond that. I hope there will be some sanctions in place. I'm not sure what the judge will do. I can tell you, Bill, judge may be very, very calm on the outside when they're actually having the hearing and it's public and everything's on the record. But I would imagine that when they get behind closed doors, when Bill Thompson and Ann Taylor gets in his chambers behind closed doors, I'm sure he's going to rip somebody new butt. And I can guess who that one is. So there may be some punishment, but he doesn't want to do anything right now to totally flip the trial over. He wants to keep the cart slowly going towards the trial date because he doesn't want an appealable issue for her later on down the line. That's my guess at this point.
100%. I want to play a little bit of this. This was from the hearing that could still be going on right now.
54,000 views, 176 comments on just one other video of a news clip on YouTube.
And based on your research, did the story or stories continue to be shared far and wide?
Yes.
Janelle Finch is joining.
Cases received massive media coverage, saturating this county with prejudicial pretrial rules.
How about to social media?
It was also spread through social media, and people have talked about it on social media.
And do you know if misinformation and rumors ended up as a result of this information shared right from the start?
Yes, and the reason I looked at this and knew it was because in the media coverage, they discussed the spreading of rumors on social media. For example, a professor who was accused by a psychic of being responsible for this. Other references to questioning the implication of people knew about the crime before it was reported to the police and so on. So there's been quite a bit of discussion, spread of rumors, misinformation, factual information all over social media, which you'd expect in a small community such.
Mike, one of the things, and you could explain this to the audience, is there's something called, and I might pronounce it wrong because my French is bad, a voir dire, right? And that is where the defense and the prosecution gets to pick jurors, and they both have 2 or 3, I'm not sure exactly, preemptive strikes. They can strike some people for no reason whatsoever. They don't like
peremptory strikes.
Right, peremptory. I used the wrong word. So I don't. They're spreading all this other. You can't prevent the press from reporting a crime story to the public. And that's what this survey company seems to be hanging their hat on. But this isn't the time to do a jury survey. That is the time to do that is when the voir dire, right?
Right, during voir dire. There's two kinds of challenges that the defense or the prosecution can use. There are peremptory challenges, which are limited. You can say, you may feel like, oh, I don't think that juror is going to really be, maybe they're too old or too young. I have a feeling about them. It's an instinct. They're very limited. You could limit, there might be 6, 8, or something like that, just a few. And you could, when you tell the judge, I want to strike juror, possible potential juror number 5 or potential juror number 12. Why? Peremptory challenge, Your Honor. And so the judge will say, okay, that's 2. You got 4 left, Mr. Geary. That's it, sort of thing. Then there's challenges for cause. And you could use a challenge for cause, and they're unlimited. And so long as you have a cause that the judge will recognize as being valid, he will then strike the juror for you. But if the judge doesn't agree and says, no, your reason for wanting to strike juror number 7 or potential juror number 12 is insufficient, that's it. That juror is going to stay on the jury panel, and that's it. So they will be at the trial. So jury selection is really important. But that is how juries have been selected in America for over 100 years. And so the idea now that we're going to have a group go out there and hunt around on their own, seeking the pulse of the public's imagination regarding the case, is very different grounds. And it brings up a lot of issues with, the news media. They're free to do what they do. You can't control them. The prosecutor can't control them. The defense attorney can't control them. We remember all the crazy rumors, but those rumors did not come from the DA's office. They did not come from the defense attorney's office. They came from social media, similar to like a newspaper. You can't stop that sort of thing. And, for Ann Taylor to take this step, thinking, she may in fact get away with it and actually kind of force the judge to grant her change of venue, it's very cynical. The judge may say, you've screwed yourself on this one. If you've now lost 400 potential jurors, and some of them may have actually been jurors that may be a little bit favorable to listening to Mr. Kohberger's side of the argument. If I'm judge, I want the trial in my county. That's how I feel about it. But we'll see what he does.
I think that the people of Latah County also want this trial to be in their county, since
Sure.
they're the county that suffered the loss of these 4 young men and women, or 1
That's right.
man and 3 women. And the town suffered, the university suffered,
Mhm.
and they want to see this through to the end, as well as the parents of these. This is like the face of the Idaho 4 students,
Right.
Steve and Christy Gonzalez,
Yeah.
and the pain on their faces, is just, you can't even calculate it. And, look what's been, besides their daughter, their lives have been taken from them, and so this is still victimizing them with all of these legal maneuvers and everything. And of course, we want to make sure everything was done correctly. Let me go back to the hearing for a little bit, just to get the feel of what this is actually about.
Did your review of all of this information tell you as a professional, as an expert in your field, that a survey was necessary in Bryan Kohberger's case?
Yes, based off of the media coverage that I reviewed, which was over 200 plus articles, and the television coverage, I thought it was appropriate to move forward to see what impact, if any, this coverage has had on the community.
What kind of survey did you think would be appropriate?
We always use random digit dial telephone surveys in these cases.
before you tell me a little bit more about that, I want to understand the history of this kind of survey. Is this something that you just made up all on your own?
No.
Where does this come from?
So these surveys have been done for decades. The first one I recall that followed a similar design and focus on case-specific items was done in 1979. Constantini and King in 3 cases in Yolo County, California. This approach was done, Dr. Ed Bronson, who I mentioned, my mentor, has been using it for decades, 40 years or more. Other experts in the field do it. John Walker, from the American Taliban case, they used a similar approach.
That's all well and good, but Mike, what we're talking about here, this is a survey, and when we think of it in light of that, the defense attorney and the defense wants a change of venue. So it's almost like, let me taint the jury so they have no other alternative than for the judge to grant a change of venue, which is a smack in the face, I believe, of the people of Latah County, the people of the University of Idaho, the families of these victims. Oh, now, of course, everyone wants Bryan Kohberger to get a fair trial. I want him to get a fair trial. But if he's guilty, I want him convicted. But the other thing is, we also want a fair trial for these people right here. We want a fair trial for them because they're the ones that are suffering most for the loss of these children. Ethan Chapin, Kaylee Gonsalves, Zana Knodel, and Madison Mogan. Let's never forget that this trial is about them. And it just so happens to have a defendant who is right here, and Bryan Kohberger, all right? And again, I will say it because if I don't say it, so many people are going to say, oh, you just say he's guilty. He's innocent until proven guilty. That's our system, all right? But we also have to realize that there are people in this case, and there are real victims in this case. And there's the real victims right on the screen there, all right? And there's more victims than those victims. Their families are victims. And of course, we want everything to go smoothly in this. Look, this case is dragging on. It's not now going to go to trial to probably 2005. And how do the people from the community feel about that? How do they feel about it dragging on to 2005? There's no way they could just expedite this and get it, because the defense they're playing the old 4-corner offense. Dean Smith from North Carolina, just stall. They're stalling. That's what this is. It's a stall.
Billy, when you've got nothing in your hand, you got to stall because you can't show your cards. Ann Taylor's got nothing. And I just want to make a quick comment. Nancy H. made a great comment. She said that Ann Taylor probably knew all the questions that company was going to ask. And I think, Nancy H., you are absolutely right. There was no way Ann Taylor would not draft those questions and give them specifically to that company, because she would want that company to ask certain questions that were actually specific and unique to this case. So good thought. I agree 100%. Yeah, this is it's a disservice to the community. But again, her ethical obligation is to, Mr. Kohberger and no one else. She's not there to seek justice for the families. She's not there to seek truth. She's there to do her best to challenge every bit of evidence to the best of her, to zealously do that to the best of her ability within our guidelines. Now, I think if I'm the judge, I would just tell her, look, we're not moving this case. And, you have just tainted the jury pool to your disadvantage. And we're going to call in, 200, 300, 400 people, whatever it is, however many we got. And that's it. Or he could say, I'll grant the change of venue, and then, it'll be tried in another county, which I've been looking up after we talked about this earlier before we started the show. depending on state law, if there's a change of venue, the prosecutor, the defense attorney, and the judge may actually go to the other county and actually have to drive there or be housed there every single day. Or it may be given completely to a new set of judge, defense attorney, or prosecutor. But that would delay everything. Or the third option, I was doing a lot of research, you would actually pick the jury in another county and then bus them into Latah County and have them sit. And every day they would have to actually be that much farther away from their homes. So whatever's going to happen, I'm not sure which is going to happen, which of those three choices is going to happen, but she's trying to throw, a monkey wrench into the machinery. And that's where this is going.
Someone just in the chat said there's a live hearing going on right now. That was what I was just playing. Those notes from it. I was just playing that. I just don't want to. The hearing started, I believe it's 7:00, and we're getting into some of the different, permutations of what's going on here. This all started last week, of course, when they had a little battle in the courtroom. I want to play Banfield here and see what she says about this.
That honestly can end in the death penalty. Nothing is simple. Nothing is cut and dry. Nothing goes exactly the way it goes in other cases either. And you might want to keep that in mind while I tell you about Bryan Kohberger's latest chess move to keep him from the firing squad in Idaho, because they're building the firing squad chamber because of this case. He was back in court today in that same teeny tiny little Latah County courtroom where he is, of course, supposed to stand trial. That's the courthouse. That's the courtroom where he's supposed to go on trial for the murder of those 4 innocent University of Idaho students. If you can believe it, it's already been a year and a half. To be clear, Kohberger will stand trial unless he pleads out, right? Unless he pleads guilty at some point. But the question remains, where? Where is he going to stand trial? Because the defense does not want that little teeny tiny courthouse in that little teeny tiny county. They want that trial moved. And this is what they're claiming. And let me quote them. The jury pool in Latah County is biased. I'm going to repeat it. The jury pool in Latah County is biased. Now, how would they know that? How would the defense know that? Have they spoken to all of them? Turns out that's exactly what they were up to. They've been on a bit of a stealth campaign lately. Clever little research project, if you will. They hired a psychologist to survey the residents of Latah County. And they got their tentacles way the hell out there. 400 people were reached by that survey. 400 people in that county. Kohberger's team asked them a whole bunch of things, like whether they had read or seen or heard about the murders. Had they heard about a knife sheath? Had they heard about DNA? Had they heard about a white car? And if the survey had only stopped there, then all the business in court today actually might not have happened. But that's not where it stopped. Kohberger's team decided to ask a few more things. Like they asked about cell phone towers and about Kohberger driving around alone on the night of the murders and about media influence on police and on the courts. And then the defense actually admitted that some of the questions they asked on this survey were not even factually correct. What? Quick. Did they say the quiet part out loud? Some of the stuff they put on the survey was not factually correct. I'm going to have a longer conversation about that in a hot minute. But correct or not, potential jurors that got this, they were confused, they were alarmed. As it turns out,
Mike, this is really, I think it's pretty ugly when you think about it, because again, we spoke about voir dire, which is the process in court where the defense and the prosecution picks the jurors. Where's this survey coming from before they're in that voir dire process? It's against everything, and it's also a shame because both the prosecution and the defense were held back by the dissemination clause, which is a gag order issued by the judge. And the defense decided they didn't have to abide by that.
You know, I agree with Ashley Banfield in one respect. You know, if they just asked, did you hear anything about the case? Have you made up your mind? You know, did you hear about DNA? Did you hear about a white Hyundai? Did you hear about DNA, cell phone towers? That would have been bad enough. But the thing is, you probably would not have found anybody in the United States that hadn't at least heard of the case at least once through some sort of media, television, online, and things like that. But but Banfield was correct. Once they went forward and started saying, you know, did you hear about the white car that was driven by Kohberger near the area? Did you know that people were in fear, hiding behind closed doors until he was arrested? You know, they're starting to put all these little other kernels in there, and it goes from being okay, maybe acceptable, to, you know, over the top. And I'm hoping that judge, you know, they move the trial to another county, or select from a pool in another county, and just drive them every day into Latah County. I don't want to see this trial delayed. Kohberger needs to have his trial. He needs his day in court, and he's pleading not guilty, so he needs his day in court. And the victims need their justice for their families, the loved ones, the prosecutor. The public needs to have this case over with. And so therefore, I don't think these delays in the long run are going to help Mr. Kohberger whatsoever. I don't see them working out the way Ann Taylor may think. I don't see it.
In that way, Mike, I just think it's really like we talk about prosecutorial misconduct. How about defense misconduct?
Mm-hmm.
I think that this is rising to that level. And I wonder if the judge will maybe privately, or a little sidebar, as they say in the business.
Oh, yeah.
Talk to Ann Taylor and say, you do that again, you're going to have a big problem. Do anything like that again, you have strike 2, right? The next one is strike 3. And because if he doesn't do something like that, he's going to lose control of this courtroom, and he's not going to be taken very seriously.
And remember, you know, the judge will make 100, you know, answer 100 motions where they will rule on objections throughout the entire proceedings. You do not, as an attorney, either prosecutor or defense attorney, piss off the judge, because they can make those rulings against you, or they can make them for you. They're like the baseball pitcher. Like I tell my students, we want their judges to call a fair game. We want them to be even-handed. But if you tick the judge off, you may get a lot of other. There's a lot of ways for the judge to get back at you. The motion to introduce the alibi, that's still pending. She has 1 week to come up with a name of a live human being that can back up some sort of make an alibi for Kohberger. So far, she hasn't done it. She's gotten 2 extensions. The judge might say, that's it, over. You will not be able to tell the jury anything about an alibi. You can't claim that there's an alibi in your opening statements. You can't claim there's an alibi in your closing statements. You cannot use that term during the trial. So you don't want to tick off the judge when you have these motions in front of the judge and he hasn't yet ruled on them. That's not thinking well long term. Not at all.
You know, Mike, that's amazing, because people haven't even thought about that. Is that because they said he had an alibi,
right?
People think, oh, they can just get away with that. She either has to come up with an alibi,
mm-hmm.
or an alibi witness,
right.
Or the judge can basically order her not to use that as a defense.
That's right.
And many people don't know that, including myself, and you just educated me And so important to realize that. And that was a big part of their defense. Oh, his alibi was he was just riding around, which he does every night for 3 or 4 hours, and freezing
Right.
cold weather in a snowstorm, icy roads and everything. He just likes to drive around and pull into people's houses and then come back later in the morning to check on his handiwork. So it's that's interesting, and I'd like to see how that's going to play out also. Folks, this is Police Off the Cuff, real crime stories. If you like real crime, true crime, from a police perspective, then you're in the right place. And if you're not subscribed to us, go on our YouTube, hit that subscribe button, give us a thumbs up, ring that bell, hit the like button, share us with your friends and your family. If you want to contribute to us financially, we have a Patreon with 3 different levels, and we also have a YouTube channel membership with count them 5 different levels. And we appreciate our friends, our fans, our subscribers who make this show what it is and make it go. I want to play a little bit of this. Here we go. This is from Law and Crime here.
Someone to do a survey of potential jurors in Latah County, where University of Idaho students Maddie Mogan, Zoe Gonsalves, Ethan Chapin, and Xana Kernodle were murdered in a house off campus back in November of 2022. The reason for the survey? To see how tainted or biased the residents of Latah County might be against Bryan Kohberger. Prosecutors say the defense conducting a survey is not a big deal. But what has them so upset is the questions the trial consultants asked the 400 residents that they called on the phone.
Have you read, seen, or heard if Bryan Kohberger owned the same type of car recorded on video driving in the neighborhood where the killings occurred? Have you seen, read, seen, or heard if the cell phone tower data showed that Bryan Kohberger made several trips near the victim's home in the month before the killing? Have you read, seen, or heard if the university students in Moscow and their parents lived in fear until Bryan Kohberger was arrested for the murders? Have you read, seen, or heard if Bryan Kohberger said that he was out driving alone on the night of the murders? Have you read, seen, or heard if Bryan Kohberger stalked one of the victims? Have you read, seen, or heard if Bryan Kohberger had followed one of the victims on social media? Your Honor, there is absolutely no question but that those questions are disseminating by means of communication, evidence expected to be presented, evidence that could be or would be inadmissible at trial. And I will say there are a number of these representations placed in the form of a question, but representations of fact that are not true or that would not be offered at trial.
Now, so much of this information is already out in the public, but Prosecutor Bill Thompson argues that doesn't matter. He said putting it out there again violated the court's non-dissemination order, an order the defense actually requested. Here's defense attorney Ann Taylor.
This court and counsel knows how much coverage this case has received. And he does what he does by looking only at what's in the public. We didn't provide him any police reports. We didn't tell.
I'm sorry. It's just that does miss the point. I mean, it's kind of ironic that we have worked so hard, including you, okay, both sides, to protect a fair trial, okay? And our concern from the very beginning was all the media stuff floating around, okay, that affects your client, Mr. Kohberger, to get a fair trial. And some of these questions actually create a concern about, that they're inculpatory. It could be prejudice for his client, okay? And that I'm just surprised that both of you didn't come together and say, there are certain things that we probably shouldn't put into the public on a time.
Lou Lemoracco, thank you so much for the $10 super sticker. Very much appreciated. Getting back to the, to the whole gist of this is that the defense is trying to get a change of venue, and they're breaking the rules to do that. And I think that, it's clear when, to me, when Ann Taylor says, we didn't provide any police reports, of course you didn't, because first of all, the police reports are provided because of FOIL, the Freedom of Information Law. And if the press requests it, and if it's not like grand jury minutes or something like that, that is secretive by law, then the police department has to, or the prosecutor has to provide it. So no defense attorney, the FOIL law doesn't apply to the defense. A newspaper's going to say, oh, we'd like to know the defense you're providing for your client. We'd like to have all the paperwork. I mean, that's ridiculous.
Right.
So when she argues that, I'm just like, it's almost like the judge should laugh at that,
Yeah, Billy, he was being very gentle, on tape, in a live TV. He was being very gentle, kind of like, oh, this is quite ironic that, you, Ms. Ann Taylor, who, would complain early on that of the prejudicial material out there that's being stirred up by social media and the press, you want a gag order, you want this, you want that. Yet it's quite ironic that you yourself are actually tainting a jury pool. And, my feeling is, Judge is probably an excellent poker player. He's not going to tell you, he's not going to let you know what he thinks. He's only going to talk on the record. He's going to be very, very careful. But he may punish her for this, short of an official complaint with the, bar association. But he will get a handle on this. He's been trying to make sure that Mr. Kohberger has absolutely no grounds to complain later on that he did not get a fair trial. So he's bending over so far backwards. He's like an acrobat, and he's doing the best he can. But everybody has their limits. He still has to conduct a trial that's orderly and that's fair. And when he sees this sort of behavior, really Bush League behavior on her part, he's going to take her to task for it, and she's going to pay for it. There's no way that she's going to get past this without some sort of punishment to her, and perhaps hurt her case through her own, possible misconduct. Unfortunately, as we talked about in the show, if she is, depending on how she's punished, that could, and if Kohberger is later convicted, he may have a grounds for appeal based on incompetency of counsel. So the judge has to, thread the needle very carefully with this and how he approaches.
Mike, I understand that, but I think and not to disagree with you, I think she is very competent counsel.
Oh, yeah.
She's just pushing the envelope beyond where a judge will put up with it. And I think either John Judge, either he does it public or he pulls her on the side and says, you pull something like that again, you're going to have a big problem. Because I think this is borderline prosecutorial misconduct. And I'd like to hear from the chat. There's got to be some lawyers in the chat of what you guys think about this. Some people got to be thinking that this was okay. Or I don't know, a survey, a 400-person survey, before they've even gone close to picking a jury. And in the town, in the county, Latah County, where they want to hold this trial and where the defense does not want this trial to be. Can we spell it out any clearer than that?
Right.
I don't think you can. I think it's obvious what the defense is doing. They're trying to get it moved to another county. And there's many reasons why the prosecution doesn't want that. There's many reasons why the judge doesn't want that. There's many reasons why the community doesn't want that. Where the university doesn't want that. They don't want this moved out of where it occurred, because they've had to put up with all of the grief, of the pain, of all the ways this affected the lives of everyone that lives in Latah County, and then to move it out to another county because the defense doesn't feel their client can get a fair trial. And what are your thoughts, Mike? Do you think he can get a fair trial in Latah County?
Bill, it's possible he can get a fair trial because, there may be people out there who are like, okay, yeah, everybody's heard of this case. There's not a single person that hasn't heard something about this case. Absolutely anywhere, I think, within the United States. You have to be a survivalist in a fallout shelter, 6 feet underground, waiting for the zombie apocalypse to not have heard about this case. Everybody's heard about it. Now, what you're looking for is someone who is willing to give both sides a fair hearing, and that is an untainted juror. And so, yeah, I think you could find 12 people who are actually willing to listen to both sides before they make up their minds. I think even with this idiotic stunt on her part, I think you can get a fair trial. And I would hope that that Judge would say, you will not be rewarded for your misconduct. We can't reward your client for your misconduct whatsoever. You can't have it take advantage of, get an advantage by actually violating the rules of criminal procedure, of the rules of evidence, of a gag order, that sort of thing. So I'm hoping the judge will just say, it's over. This is it. We're going forward. Oh, by the way, within 48 hours, I want to know about your alibi, witness, because I'm going to rule on that. I hope that they stay in Latah County and don't inconvenience anyone else. And I think you probably can get 12 people who are at least willing to listen to both sides of the argument. And that's, I think, all you can hope for.
I agree. Mike, you have a fan in the chat.
Oh, yay. Okay.
Boombots, I'd like to reiterate that Professor Geary is a man's man.
Well, thank you. Thank you, Dr. Vinny. Thank you.
We love to hear that. So, yeah, I mean, the judge, look, as you know, and you said it before, as a defense attorney or as a prosecutor, you don't want to piss off a judge. You don't, because he or she, whoever happens to be the judge, in this case it's a he, is going to make the decisions sitting, a few feet above everyone else in that courtroom. And that's done for a reason, that a judge sits higher than everyone else to give him that elevated status. And, you do not want to piss off a judge. That's the bottom line. And she may have successfully accomplished that she did piss him off.
Yeah, I guess in a football sense, it's a Hail Mary pass to try to get this case moved out of the county. And, they don't always work. There's not always that miracle catch at the end. What she's doing is, for a short-term possible gain, she may lose a lot of credibility with the judge when during the next year and all through the trial, whenever it comes, there will be, 100 decisions he has to make, and many more of them can go against these are discretionary, things that he has plenty of discretion, so long as he's not outside the realm, the pale. He has tremendous discretion on rules of evidence, motions, and everything else, continuances, you name it, the actual charging language to the jury, all of this sort of stuff. It's all within his purview and his control. So therefore, she may have actually cut off her nose to spite her face, looking for a short-term gain, but in the end, actually not doing anything to help her client whatsoever.
I agree.
This team for the man accused of killing 4 University of Idaho students was scolded by the judge in the case.
It comes after the defense was accused of tainting potential jurors in a phone survey. King 5's Greg Copeland is here with us now to walk through what happened today, Greg.
So, Jessica, the defense team hired a company to conduct this survey. They called 400 people living in Latah County, Idaho, where the murders took place, asking them what they knew about this case. The state said it had no problem with the survey itself. It took issue, though, with some of the questions that were asked. Kohberger's defense attorney says she did not see the questions and the company created them based on media coverage. The state claims some of the questions violated a previous order by the judge saying attorneys cannot disclose case details with the public. The survey company did not know about that order because the defense team didn't share it with them. Today,
I find that to be out and out bullshit. Call it what it is. They did not know about it because the defense, then the defense is negligent and the defense needs to be disciplined. They didn't tell them. That's it's not even believable. It's not believable.
Not at all.
The prosecutor read some of the questions after receiving complaints from the community.
Question: have you read, seen, or heard if police found a knife sheath on the bed next to one of the victims? Question: have you read, seen, or heard that DNA found on the knife sheath was later matched to Bryan Kohberger?
The damage has been done. We've been working very, very hard to keep the sort of noise out of the case. And now it's been injected, at least to these 400 people.
Nobody's injecting anything into the case. A random small percentage of the
Look how cocky she is in that she's almost, I mean, she's raising her voice in the courtroom, perhaps to prove a point. But I find it like, wait a minute, you better be a little more humble than that because you're wrong, So you better take a little humble back seat or eat some humble pie.
The population is contacted. Have you read, seen, or heard things that are lifted straight out of the media?
Just one thing after another. In this case, prosecutors asked the judge to make the defense start its survey all over again and then also approve the questions. The judge did not make a decision today. There will be another hearing next week. Until then, the defense team cannot continue surveying people, which will delay this case even further.
So it's unbelievable when you think of it. But I mean, this was from last week, so he was referring to tonight's hearing, which that they were discussing. But when they said that this company was not apprised by the people that hired them about I just, come on, stop it. Are we supposed to believe that?
It doesn't pass this, what I call the straight face test. Could you say that with a straight face? And if you can't, because you start laughing because it's so ridiculous, then it's false. Obviously, she wanted the survey done. She contacted them. She gave them the parameters. She probably suggested the topics. And she probably, and in my opinion, my humble opinion, she probably reviewed the final draft of the questions. Because why would she not? She wants to make sure that she has certain information out there and that enough people will respond to prompts that she is controlling for them to hear so that she can tell the judge, Your Honor, look at these things that the jury is actually have already made up their minds about, prejudicing my client's defense. So if she didn't control the questions, I think she would be idiotic, even more idiotic than she is. She is absolutely controlling. She hired these people. She suggested the questions. They probably worked together to word them properly. She was absolutely there every step of the way. She knew what was going on. And for her to stand up in court and say, Your Honor, these questions were of topics that were already out there in the news media. It's like, wait a minute, you're missing the point of why we're here in the courtroom. It's crazy. It's really crazy. The best defense is a good offense, I guess. So she put on the offensive.
Tom Cusinelli, if I was the judge, I'd be out of my mind. We are not trying to make it that this judge doesn't have a very difficult job. He does. He's damned if he does, and he's damned if he don't, because he's concerned with making the wrong decision and being too harsh one way or the other, and would open this case up even after potentially a conviction of an appeal, or but he can also lose control of the courtroom, and that's what we're really concerned about. that he could lose control of the courtroom and the defense run roughshod over him, which it seems is happening right now. DMART, these shenanigans are one reason why people vilify attorneys. It gives them a bad rap, and the system will not survive long term with hocus pocus injected into trials. Horrible for victims. Yeah, DMART, it's a double-edged sword, though. It's a very, very difficult thing because he's trying to be fair to both sides, but he's also trying to apply the law in being fair to both sides. And if you ask me, she stretched the law, Ann Taylor, to the breaking point, and it did break. She broke the law, in my mind, that she, maybe not the law procedure, she violated the gag order, she violated the non-dissemination order. I think she lied when she said that she didn't know that the survey company knew what happened. Like, please, that's not even believable, you know? And so it's Barbara Crossley, I think so too. She wants to know all the evidence. Pauline Buckles, I'm sure Kohberger had a hand in crafting the questions. I don't know. I don't know. I'm not sure of that. Cheyenne RN, so many attorneys are crooked who get an appeal on his unethical attorney, put her in jail. You guys are throwing people in jail already. No one's going to jail. I want to bring us back to when this happened and just to the reality of what this case is all about.
Front of the King Road home where 4 University of Idaho students were murdered 7 weeks ago. This morning, a suspect is behind bars in Pennsylvania, and this morning we're breaking down every detail of this case after weeks of investigation and thousands of tips coming into police here in Moscow. So we do have team coverage for you this morning. Channing Curtis is in studio breaking down everything we know about the investigation process so far and how the community is reacting to this arrest. We also have meteorologist Thomas Patrick tracking your New Year's forecast. But before we get to them, we want to get a closer look now at who this suspect is and how this arrest was made. So let's take a look here. Early Friday morning, Pennsylvania State Police arrested 28-year-old Bryan Kohberger for the murder of 4 University of Idaho students. Those students were found stabbed to death in their home near campus 7 weeks ago. Kohberger is a PhD student at Washington State University. CBS News learned forensic analysis allegedly linked the suspect to the crime scene in Moscow, Idaho. He has been charged with 4 counts of first-degree murder and felony burglary. Police still not saying whether the suspect and the victims knew each other. Meanwhile, Pennsylvania State Police arrested Kohberger 2,500 miles away from the Idaho crime scene. Authorities found him at his parents' home early Friday morning. Kohberger is now awaiting extradition back to Idaho. His attorney says he plans to waive his extradition hearing during a court appearance happening tomorrow. That means he could be back in Idaho sometime this week. His family and lawyer issuing statements on his arrest. The statement from his family reads in part, "First and foremost, we care deeply for the 4 families who have lost their precious children. There are no words that can adequately express the sadness we feel, and we pray each day for them. We will continue to let the legal process unfold, and as a family, we will love and support our son and brother." Kohberger's family also saying they are fully cooperating with law enforcement in the investigation. Meanwhile, Kohberger's public defender in Pennsylvania also issuing this statement. He says, quote, "Mr. Kohberger is eager to be exonerated of these charges and looks forward to resolving these matters as promptly as possible." Following the announcement of Kohberger's arrest on Friday, law enforcement held a press conference for the first time since November. This was the biggest break in the case, and police gave us more insight at how they came to arresting Kohberger.
We have an individual in custody who committed these horrible crimes, and I do believe our community is safe. These murders have shaken our community, and no arrest will ever bring back these young students.
The details of what led to the suspect's arrest won't be released just yet. That's because of Idaho state law. In December, investigators revealed they were looking for a white Hyundai Elantra. Right now, police say they found that car but are still looking for a murder weapon. Now, for the families of those 4 victims, this obviously allowing them to begin having some sort of closure and also bringing justice to their children. We actually had the chance to speak to the father of Kaylee Consalves, who tells us this is the first time his family has had an ounce of hope.
This is the first bit of joy that we've had in close to 7 weeks. We hope that they picked the right guy, and that gives us hope, and we haven't had hope for a long time.
And we also heard from the family of Ethan Chapin. In a statement, they say, quote, "We are relieved this chapter is over because it provides a form of closure. However, it does not alter the outcome or alleviate the pain. We miss Ethan, and our family is forever changed."
So that goes back to December 2022 when he was arrested, and we remember that when he was arrested, a lot of the information came out from, of course, the arrest affidavit, which outlined the probable cause affidavit, those things, and that is what Ann Taylor was hanging her hat on, that has prejudiced the Latah County community, with all of the information that was released by the prosecution and by the press, constant 24/7 reporting on this. And some of the information perhaps isn't even correct, but they used incorrect questions in their phone survey of the 400 people in Latah County, didn't they?
That's right. You know, she can hang her hat on the fact that other people had given misinformation out there and all kinds of wild rumors and speculations. She can do that, but the fact is she still has to answer for her own conduct in conducting this survey, which was highly inappropriate considering the gag order. She knew that this company was what they were going to do. She knew how they were going to do it. She knew the questions that were going to be asked, and she knew she was violating the gag order. You know, when all is said and done, when this trial's over, whatever comes of it, you know, she can be disciplined by the State Bar Association, you know, that sort of thing. But and I hope they do, because this is, you know, is pretty egregious, especially when you've already gotten a gag order in place and the judge is telling you you will not communicate with potential jurors, you know, and you're deliberately trying to, you know, taint the jury pool. She's saying she's trying to measure the jury pool, but really by interjecting facts and things that may or may not actually be true, she's actually tainting the jury pool. But this is going to take a while longer. We're going to need a lot more patience before this case is finally done. It's amazing.
You know, Mike, someone from the chat is asking you a question. Professor Michael Geary, what do you think about the university's president, Scott Green, writing a book detailing some of the university's involvement in the investigation?
I got to shake my head at that one. I think that's terrible. Anything about this case that the public doesn't know through, say, the media, through, you know, official press briefings or something like that, you know, anything else is gratuitous and doesn't need to be released or mentioned, because that may taint a jury pool. That would play perhaps into Ann Taylor's hands. You know, we know there's a number of authors that are looking to write or actually are presently writing the book, but for that book to be released before the trial, before the picking of the jury, I think would be wrong. I mean, you know, he's not going to be arrested, you know, that sort of thing, or fined civilly. But I think it's really wrong. If the president has something to say, he can say it after the trial is over. And I hope whatever he does won't be released until after the trial is over. I'm hoping.
Elisa Krogan from the chat, seems like Kohberger would want the trial as soon as possible to hear the evidence and make his case. Well, yes and no. This is keeping him in the limelight. I'm sure he loves that, but he's in jail. And if he in fact is guilty and he gets convicted, he's eligible for the death penalty. And he will surely get it in this case if he's found guilty. And of course, he's innocent until proven guilty. Talks to angels. I remember Bryan doing that survey. He was asking about murder too, if I'm remembering correctly. It was really bizarre. Talks to angels, you're 100% correct.
Right.
He did a survey of criminals, asking them questions in his survey. So you're absolutely right. And let's not forget he was a PhD student in criminology. But that doesn't mean, because he's a PhD student in criminology, that doesn't mean he knows the law the way attorneys know it and the way people that study the law do. Sherry Murray, thank you both Sergeant and Professor for keeping us all in check about these different cases, teaching me a lot. Sherry, thank you very much. It's always, as I said on the last show, I think we all that learn things, we all cherish the thought of being a student for life, always learning something new. And once you stop being a student, you'll stop learning, so we can all learn from each other. That's for sure. Eliza Krogan, right? And we want to see the evidence hopefully before the next total eclipse. Yeah.
Yes.
It's moving that slow. You're right. Pesa, the initial statement from his defense attorney was that they wanted a prompt conclusion. Defense attorneys say a lot of things. Many of them are not true, but Dr. Vinny Boombatz, I would that as a PhD student, he knew very little about most things. Yeah. Well, it seems like, these days, so many people have PhDs. Lula Morocco, waiving his right for a speedy trial. Was anyone else arrested? No, for sure. No one else was arrested. Look, so many things about this case. I would like to know everything that the prosecution has, Lou. Lou, I think they have a lot of things. They have a lot of cards up their sleeve that we don't know about, and that's where, the defense does know about it. And do you think the defense maybe purposely, accidentally on purpose, leaked some discovery material to the press for their own purposes?
Perhaps. This is the game of chess that is played, before the trial begins, during the trial. This is the chess match, the strategy. What does everybody's looking for an advantage. So anything that they can do within the bounds of ethics, within the guidelines of ethics, the canon of ethics, they can do. And there's nothing wrong with being a great strategist, not at all, so long as they're doing what is ethically available to them. But Bill Thompson and Taylor, they both want to win, and they both want to win badly. This is the Super Bowl. This is probably, I know Bill Thompson has done at least one other death penalty case, but this is probably, I would imagine, the most highly publicized case that he'll ever work on. And for Ann Taylor, I think the same thing. There's a lot riding on this case, not only for Mr. Kohberger and the community, but also their careers. So, they're doing their best to win this match.
Lou Morocco, I misunderstood you. Yes, he did ask, Bryan Kohberger did ask, was anyone else arrested?
Yes.
When he was arrested. You're right. Mm-hmm. That went over my head for a second. I can't think of everything. But, someone asked in the chat also, Mike, why did he waive his right to a speedy trial? Maybe you can answer that.
I think Ann Taylor, wanted him to waive his right to a speedy trial because originally, if you remember, so many things have happened. But originally, I think when he was arrested in late December, early January, he's back. For the first time, he's in Idaho. He's arraigned on the indictment. they're starting the pretrial process. I think the original target date was an October 23 trial date. So that would have given him 7 months to prepare from the time he'd landed in Idaho, is put in jail, until the time that the trial starts. But with all of the mountains of discovery and all of that scientific evidence between the cell phone towers and the DNA evidence, Ann Taylor felt that she couldn't, consult with enough, experts and come up with a good defense strategy to combat all that evidence in a short time frame between, by the time they started getting the information discovery, they might have gotten some of it in March, some of it in April, some of it in May. So she's looking at a very compressed time frame. And that's why I think she waived his right to a speedy trial, to give her and him extra time, an extra 6 months, an extra year, because she wants to bring in experts to challenge the reliability and the accuracy of that DNA evidence. If they could knock out or plant seeds of doubt in the jury's mind about the DNA evidence, then they could explain away the cell phone tower information, and they can explain away other things. But that DNA evidence is huge. So I think she did it strategically in order to better prepare her defense.
Absolutely. Lou Lemoracco, thank you so much for the $20 super sticker. So much appreciated. Thank you. Folks, one of the things I just wanted to sort of go back right to the beginning, and it's right here. Kohberger's defense team accused of tampering with the jury pool. Now, that's the whole purpose of what we were speaking about on this show. And some may think, oh, no, she wasn't tampering with it. She was just trying to, get him to be a good defense attorney for him. But she violated a gag order, or non-dissemination order. So right there, that's dirty pool. It's not okay, And I'm sure in tonight's hearing, it was live while we were on. Those are, to watch the whole thing, to me, gets a little bit long-winded. But to take out the real pertinent points, they basically hired a firm to do a survey because they want to get the damn case moved out of Latah County. That is it in a nutshell. They could have had a 2.5, 3-hour hearing about that, but that's what happened. They were trying to taint the jury themselves, I believe.
Bill, that's what they're doing. They're planting the seeds and then claim later on that there's no way that you can get a fair jury. So that you can't do that. You can't, violate a gag order, violate a court order, be in risk being held in contempt by the judge, and consider yourself an ethical lawyer and within the bounds of ethics by doing what you did. You can't do that. It's violative of your rules of ethics. You're supposed to zealously advocate for your client, but zealously advocate within the bounds of your ethical guidelines. No way, no how. This is going to probably bounce back and hit her right in the chin. And whatever penalties are assessed against her in terms of her professional record, or in terms of how the judge handles this going forward with the jury, I'm sure it's not going to go the way she planned. I doubt it.
100%. I just want to always, with this case and cases like these, I always like to circle back to the victims here and mention their names. Ethan Chapin, Kaylee Gonsalves, Zana Knodel, and Madison Logan. That's who this case is about. And we who cover these cases and we who listen to these cases, the true crime community, can't ever forget that. We can't ever forget the faces of these two people, Christy and Steve Gonsalves, that have been the sad faces of the parents of this case. And you can't even imagine the pain and suffering that they've gone through in the last year and a half. That's about our show tonight. Mike, your final words.
As usual, I'm going to ask everyone to have patience because the wheels of justice grind very slowly forward. And, it does look like this case will not come to trial probably maybe a year, maybe next summer, maybe next June, maybe at the earliest, if it's going to be held in Latah County. And I hope it is held in Latah County. And if it is, it might be next summer at the earliest. It seems ridiculous, but this is the way our system works. And so please, everybody be patient.
Absolutely. Lieutenant Peter Pranzo, this case may hinge on a single juror. Absolutely, Lieutenant Pete. That's and Schmitty, so much of Mom on my mind. Thanks for the show. Good night, Schmitty. Thank you for stopping by. All you guys, all our subscribers, all our friends, all our fans, we want to thank all of you guys for stopping by tonight. There's always a lot to learn with this case and so many cases like this. And we love to bring it to you. Have a great night, everyone. Thanks for coming by, and God bless.
Good night.
One episode just ain't enough.